Tonight on The ReidOut.
Find it just so out of sorts with the basic value system of the American people. And I think that across the board, the vast majority of the American people don't agree with a lot of the decisions this court is making.
President Biden, in an exclusive interview with my colleague Nicole Wallace, responding to today's very predictable Supreme Court decision on affirmative action. And that is where we begin tonight, with the United States Supreme Court once again turning the arc of justice away from equality and back to the early 20th century, striking down the use of affirmative action in college admissions. The Roberts Court, which wouldn't even look like the court it is today without affirmative action, deciding in a pair of rulings that race-conscious admissions programs at Harvard University and the University of North Carolina violate equal protection under the Constitution. It is fitting, then, that it would be the court's first black woman justice, Ketanji Brown Jackson, who clearly articulated the cost of this latest regression. Writing in her dissent, with let them eat cake obliviousness, today the majority pulls the ripcord and announces color blindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. The best that can be said of the majority's perspective is that it proceeds ostrich-like from the hope that preventing consideration of race will end racism. The court essentially says in this ruling that after a generation or two of racial progress in education, after hundreds of years of rank discrimination on the basis of race, we've done enough. We're all equal. Kumbaya. Everything's fine. Despite vast and persistent inequalities in wealth literally created on the backs of black Americans and kept in place for generations even after this country stopped enslaving black people on the basis of race in 1865. For the better part of the next century, America embraced the concept of separate but equal. Black students were told, yeah, you can have a school, but it's going to be a one-room shack with old, useless textbooks that's only open when it wasn't planting season. And that didn't end officially until the Supreme Court's Brown versus Board decision in 1954. And then in the 1960s, white segregationist mobs rioted when black students had the temerity to try to attend schools like the University of Mississippi. And who could forget Governor George Wallace physically blocking the doors to the University of Alabama? Apparently, at least 6 members of the court have forgotten, the current court anyway. It's only really been since the 1960s that we have had any real promise of racial equality in education or any promise of fairness in society. And that was thanks to Chief Justice Earl Warren's Supreme Court in the 1950s and 60s, which revolutionized America, dramatically expanding civil rights and civil liberties for all Americans. The Warren Court ended racial segregation in public schools, expanded voting rights, upheld free speech, legalized interracial marriage, and paved the way for legalizing abortion, all landmark changes moving us forward. But this Supreme Court, the Roberts Court, or perhaps I should call it the Alito Court, will definitely go down in history as the opposite, yanking back American progress in direct repudiation of the Warren Court and the 20th century. Justice Sonia Sotomayor, the first Latina to sit on the court, acknowledged as much in her dissent, writing that this court stands in the way and rolls back decades of precedent and momentous progress. The devastating impact of this decision cannot be overstated. The majority's vision of race neutrality will entrench racial segregation in higher education because racial inequality will persist so long as it is ignored. As for the court's conservative majority, 6 of them chose to side with the petitioner in both of today's cases, Students for Fair Admissions, which, contrary to its name, is not actually students, but rather a group led by a man named Edward Blum, a conservative legal strategist who for many, many years has been bent on killing consideration of race in college admissions. Well, he finally got a court majority that would give him his way. But according to Chief Justice John Roberts' majority opinion, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. I mean, so long as aspiring students write about the way race impacted them in their college essays exactly the way John Roberts tells them to. And with today's death blow to affirmative action, one justice in particular seemed to revel in pulling up the ladder behind himself. Justice Clarence Thomas, who has acknowledged that he has benefited from affirmative action. In a frankly gleeful concurrence, Thomas wrote, "Even in the segregated South where I grew up, individuals were not the sum of their skin color. While I am painfully aware of the social and economic ravages which have befallen my race and all who suffer discrimination, I hold out enduring hope that this country will live up to its principles." Aw, adorable. Today, in court chambers, Thomas said the policies at UNC and Harvard fly in the face of our colorblind Constitution, the Constitution that at one point deemed him to be 3/5 of a human being. NBC News reports that as Thomas spoke, Justice Jackson stared straight ahead, apparently visibly angry. In the meantime, America's colleges and universities will begin the process of determining how to maintain diversity without violating this court's ruling. Joining me now is Reverend Al Sharpton, president of the National Action Network and host of Politics Nation, Elie Mystal, justice correspondent for The Nation, Joyce Vance, former U.S. attorney, MSNBC legal analyst, and professor at the University of Alabama Law School, and David Hinojosa, director at the Lawyers Committee for Civil Rights Under Law, who argued in defense of affirmative action at the Supreme Court. Thank you both. Thank you all for being here. And David Hinojosa, I do want to start with you because you were there. You were in the courtroom as this case was being argued. Would you characterize these sort of interactions? I mean, I know in the Harvard law case, Judge Ketanji Brown Jackson recused because she actually has a moral center and a moral core, unlike the person I'm also talking about, Clarence Thomas, who takes lots of gifts. What were the debates and the argument like?
Well, Joy, of course, this is very difficult issues, right? Whether or not you can consider race, how you're considering race, and given, the incredible histories that we have here of racial exclusion and racial violence, it certainly seems fitting that we continue to have this because we've had a couple of centuries of that violence and that history compared to just a few decades.
That's right.
Of being free of that. Even at the University of North Carolina, they had, that university was created in 1789 to serve the children of slave owners at the time. And they fought for 200 years to continue to exclude black students. So we knew going into the argument that it was going to be a tough sell for this court, sure, this sitting court. Prior courts with Republican appointed and Democratic appointed justices had put aside those differences of politicized opinions. But this court, through some of its questions, you could kind of start reading through. But we did feel very strongly that the law, the facts, and the Constitution were on our side. And we had strong evidence from our own students discussing how and why it's important for them to lift up their own lived experiences and when those are affected by their race. Mm-hmm. And so we knew it was going to be tough, but we also felt that we had done what we needed to do. If this court was going to try and pull down on affirmative action or pull down on the progress that we made, mm-hmm, it should have been, very tough for them to have done that.
Sounds like it was pretty easy, though, for them. And ironically, you're the one who had the students with you. Elie Mystal, eager to hear your thoughts on this decision.
Well, let's start with the idea that the Supreme Court got it completely wrong in terms of the law. OK, the 14th Amendment, the Equal Protection Clause of the 14th Amendment, it was not passed to help white bail sons like Jared Kushner and Brett Kavanaugh get into school, OK? The first time that we had affirmative action in this country was not the 1960s. It was the 1860s. We had affirmative action during Reconstruction. And we know that the affirmative action during Reconstruction was constitutional because they ratified the 14th Amendment so that they could pass legislation that would help to revoke the racism of the past, and those policies included affirmative action. So as Ketanji Brown Jackson pointed out in her dissent and at oral arguments, the Supreme Court was just flatly wrong on the law. Now, we can all know why the Supreme Court decided to get this particular law so wrong, and it wasn't to help the AAPI students who were trying to get into Harvard and Yale. It was trying to help mediocre white students who feel outcompeted and blame black students for, quote unquote, taking their spots. It was a terrible decision on the law, but we all know the real reason why people like John Roberts did it.